Well, the White House says it's pleased with today's Supreme Court decision to not rule on a major challenge to Obamacare. A coalition of religious groups and leaders had argued against a provision requiring all employers who offer insurance coverage must include no-cost birth control for women, unless they can explain in a letter why doing so goes against their core values and beliefs. But today, in an unsigned opinion, the justices sent the case back to lower courts in search of a compromise. Senior fellow at the Cato Institute, Ilya Shapiro, is in Washington, joins us now. Ilya, can you first explain this case to us?
Sure. So following up on the Hobby Lobby case from 2 years ago, which involved for-profit companies, non-profit organizations that were not themselves churches or houses of worship said, look, we want exemptions from this mandate requiring us to cover contraceptives and other things that they objected to on religious grounds. The administration offered them a so-called accommodation. That is, you didn't have to do it the same way that Hobby Lobby and for-profit companies were supposed to, but there were certain forms to fill out, certain objections to be made, certain information to be provided, and those nonprofits still said that that was too burdensome. That put them in the chain of sin, if you will. They said that still burdened our religious exercise. And the court, as you said, did not decide that question, said that based on supplemental briefing that had come in, this should be for lower courts to reconsider and perhaps to orchestrate a compromise between the nonprofit groups and the government such that both sides could be satisfied, the groups would not be burdened, and the government would be providing this no-cost contraceptives to their female employees.
So, Ilya, based on your analysis, can a compromise be reached?
I think so, because the way that the court seems to read this, the supplemental briefing that they called for, merely making an objection seems to satisfy both sides. The tricky thing here is that if indeed that is a way to more narrowly accommodate both sides, then the challengers should have prevailed altogether on their legal claims, because under the Religious Freedom Restoration Act, which is the federal statute under which they brought their lawsuit, that says that if there is a less burdensome way for the government to accomplish its goal, then it has to do that. So in effect, it looks like the court is setting up the lower courts to negotiate this more narrow, satisfactory compromise. And if that compromise exists, which, as I said, I'm reading the tea leaves, it looks like it does, then that means the challenger should have won altogether. But of course, given the 4-4 court, effectively, that we can read into what was going on here, the court didn't want to rule that way, or could not.
And Ilya, as a neophyte looking at the Supreme Court right now, I'm guessing today's decision is a